Thank you very much, Pedro Pintolete. And now I turn to Hans Corell, Ambassador and former Legal Counsel of the United Nations and Head of the Office of Legal Affairs at the UN Secretariat, to give some of his experiences from being involved in this process.
Thank you. It's a great pleasure to be here. And I'd like to set out clearly from the beginning that as Legal Counsel of the United Nations, I was involved in almost every nook and cranny of the organization. I had an office of some 160 people. We deal with everything between public international law, including the law of the sea, to international trade law, law of treaties and so forth, and also the law of the organization, including procurement and damages and so on. So basically I never knew when I came in the morning what the day would offer by way of legal work for me. So this means that I'm not an expert as such on Western Sahara, as I'm not an expert on Angola or Zimbabwe or any other region where we had to focus. What we had to do was to provide legal advice on issues that were raised in the organization. East Timor, certainly I was heavily involved in the governance of East Timor. The United Nations governed East Timor, but I'm not going to address those issues or comment on the allegations here that Australia was drawing of the natural resources of East Timor. As a matter of fact, there was an agreement between the newly independent East Timor and Australia on the delimitation in the Timor Gap. This was a major issue for us in the UN leading up to the independence of East Timor. What I would like to focus on here is, and that's why I'm here, that I was asked to give a legal opinion on a very particular question, which relates to the natural resources of Western Sahara. And I must say to you now, frankly speaking, I was quite surprised that I, as an international official, was asked to give a legal opinion on such an extremely sensitive issue. Nevertheless, I was. So on the 13th of November, I received a question from the President of the Security Council on behalf of the members of the Council, formulated as follows. They would like to have my opinion on the legality of in the context of international law, including relevant resolutions of the Security Council and the General Assembly of the United Nations, and agreements concerning Western Sahara, of actions allegedly taken by the Moroccan authorities consisting in the offering and signing of contracts with foreign companies for the exploration of mineral resources in Western Sahara. That was the question I was faced with. So of course with my team, I don't do this on myself, just off the cuff at my desk. There's a very thorough legal examination and analysis made if we receive questions of this kind. Have we given advice on a similar issue earlier? If so, what was the advice? What does the law say, and so forth? Here, of course, this was a new question for us. A question of this kind had never been asked by the Legal Counsel before. So we had to analyze, first of all, the status of Western Sahara and also the status of Morocco in relation to Western Sahara. We had to also analyze international law, including the developments over the recent years and whether there was any precedence offered by the International Court of Justice in The Hague. So what was the law then? First of all, the UN Charter. And there's a whole chapter here, Chapter 11, Declaration regarding non-self-governing territories, of which we found that Western Sahara was one from the beginning. We had several resolutions by the General Assembly which focused on the situation in non-self-governing territories, in particular in relation to the economic activities by others in those areas. And also there were resolutions on Western Sahara. Now, what then was our conclusions? Well, the status of Western Sahara, this issue was basically dealt with by Pedro Pintolete, that he mentioned the development over the years. For us, the most important element was that from the beginning, Western Sahara was on the list established under Chapter 11 of the Charter of territories that were not self-governing. And it was Spain that was in charge of this territory. as administrating authority. But Spain then, gave up. So basically in 1975, Spain just left the territory and left it to Mauritania and Morocco. And as we heard from Bintou Leite here, in 1979, Morocco withdrew two, thus leaving, Mauritania withdrew two, thus leaving Morocco as the sole body that was involved now in Western Sahara. But for us it was also important to note that Spain had no authority to hand over its role as administrating authority to Morocco. And Morocco was not either listed as such in the official list of the United Nations. So the conclusion at this stage that I draw was that it would be appropriate for the purposes of the present analysis, I said, to have regard to the principles applicable to the powers and responsibilities of an administrating power in matters of mineral resource activities in a territory of this kind. That is to say, it was not a clear situation of a relationship between an administrating power and the territory in question. But we nevertheless had to look at that relationship when we looked at the relationship between Morocco and Western Sahara. We also looked at Article 73 of the UN Charter, where this system is set out, and draw the conclusion that any administration, irrespective of exactly how the administrating power or the administrating entity is considered, that has to be done in the interest of the population. The words used actually in the Charter is a sacred trust, if you look at Article 73 of the Charter. And also, of course, those who administer these territories, they are supposed to submit reports to the General Assembly. That was the system that was set up. But basically, this system is now completely over and done with, and as a matter of fact, the Trusteeship Council that was responsible for these territories, there are suggestions now that the rules on the Trusteeship Council should be abolished from the United Nations Charter. Now, also there was a very important resolution by the General Assembly from December 1995, where the Assembly drew a distinction between economic activities that are detrimental to the peoples of the territories in question and those that are directed to benefit them. So here, all of a sudden, we saw a nuance. This meant that in the regime that applied between administering powers and their territories, there you could see sort of a two-pronged approach. And one could see that as long as you did activity or engaged in activities that were to the benefit of the population, then basically they should be permitted, provided, of course, that the proceeds or the goods of that would come into the hands of the population in the area. Specifically, then, we looked at Western Sahara. And Mr. Leite mentioned